Okay, good morning once again. Welcome to the next session in the We Are Family PMS Virtual Family Conference for 2022. Thanks for being here with us this morning for IEP 101, Demystifying the Process. My name is Michael D'Imperio, and I'm here with my wife, Carla D'Imperio, well, across the house from her, as you can see. And we are parents to Matthew, our 7-year-old PMSer, who is the brother of our other children, Joseph, 9, and Jane, 4. And we are excited to do this presentation for you today because demystifying the IEP process is exactly what needs to be done. So a little background before we get started, just so you know who we are and why we're doing this session. So Carla actually has an educational background as a teacher in New York City, and then a manager of teachers through Teach for America. So she's very familiar with the IEP process in the educational system, whereas I don't have that background, and I've become familiar with the process, obviously, because of Matthew and because of working through the IEP process with him. And I think that that's where most people come from, is they have to figure it out as they go. So I think we have done a lot of that, but with Carla's background, it'll be helpful as well as we go through this to hear both perspectives on the process. So I'm going to let Carla take you through the session objectives and the agenda, and then we'll get started.
All right, good morning, you all. I'm happy to have you all with us today. We're excited about this. As Michael said, we've learned a lot on the ground here with IEP, so we'll be sharing it with you all today. One of the things we want you to walk away with is an understanding of the history of IEPs, where it came from, and the laws that are involved. And that's something Michael's going to take the lead on. And the purpose of an IEP, we want you to understand why we have IEPs, what is an IEP, and what it isn't. There are some misunderstandings, so we'll clarify those. Hopefully by the end of the time with us this morning, you will have gained some confidence as an advocate for your child in terms of crafting an IEP and advocating for your child in terms of the IEP. And then finally, we want you to have some additional resources where you can go if you need more support in the process. So that's what we're hoping to accomplish in the next 90 minutes. And as Michael said, if you have questions during the session, you gotta go. If you have questions during the session, please raise your hand, or at the end, we can take some questions at that time too. Our agenda here. So we're going to start out with parental rights. Michael will take us through a lot of this the legal aspect of things, including the history of IDEA and IEP. So hopefully that'll give some good legal background. I'm going to take over for what the IEP is, the process of getting an IEP, and the steps in the actual IEP process once you do have the IEP for your child. Break it down into parts, the basic parts of an IEP, and then I'll hand it back to Michael for what to do when you run into some trouble on the ground, when things don't go as planned, conflicts and disputes. And he has a nice section on Let's Get Real, some of the situations that might come up in real life. We'll give you some recommendations and then hold some time at the end for questions and answers.
So I think one of the things that's important here, two things up front. The IEP process is bigger than what we can cover in the next 90 minutes. So we're hoping, again, as Carla said, to give you an overview and some perspective on the process. If there's an interest and a need later, we can go deeper into it in another session and help people individually walk through their particular situation. But this is bigger than what we can cover in 90 minutes. So again, we're going to do an overview. I should also say up front, just give you a quick disclaimer, right? So anything we discuss today is background information. It is not legal advice. It is not legal guidance. And there is certainly not a attorney-client relationship that should be perceived in anything that we discuss today. I am a law student. I need to give that disclosure so that is upfront as well. But you can certainly ask questions and we can answer them in the hypothetical and take you through some of this. So the first thing I want to do is talk about parental rights. I think this is an important place to start, right? I think it's one of the things that has been misconstrued over the years and not fully understood. So this is a little bit, in the weeds on the legal side, but I think it's really important. So there's 2 Supreme Court cases here that I put, and I did so because you need to understand what the parental rights are, right? And I think you can read them through from Pierce's Society of Sisters way back in 1925, but most recently, and the key holding is from Troxel v. Granville in 2000. And it basically gives the constitutional right that the due process clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. As a parent, you have the constitutional right to, again, make decisions concerning their care, custody, and control. It is not within the province of the state to make significant decisions concerning the custody of children merely because it could make a better decision, okay? So I think that's important, again, to just establish that you have parental rights protected by the Constitution and statutory law that enables you to be in control of your child. That very fundamentally affects education. Now, I use the word fundamental, and we'll move on to the next slide here in a second, because I also want to express to you that education is not a fundamental right. You'll hear the term fundamental right expressed a lot, especially in the news lately, with some of the cases that are up in front of the Supreme Court. Education is not a fundamental right. It's not a constitutional right granted to us in the United States. However, since education is a function of the government that is provided to our children, those children with disabilities, her ideas we'll get into, have the protection of receiving the same education as that granted by the government to children in the United States. So that line, that delineation, that's very clear. Education is not a fundamental right, but because education is granted, our children and those with disabilities are protected and granted the same educational opportunities that are granted to other children. I know that's dry, I know that's boring and legal, but I think it's really important to understanding, because I think the term that I like the least in all of these conversations is the word demand, right? Often in conversations about parental rights, about IEPs, about what we fight for our kids, we might demand things. And I think it's important for you to understand what can be demanded and what can't, right? Education is not a fundamental right that can be demanded. Equality in the education that is brought forth to children can be. So moving on to the history and the law, again, a little bit dry, but I want to go through this just very quickly. In 1975, it was actually President Gerald Ford that signed into law what is now known as IDEA, the Individuals with Disabilities Education Act. It was reauthorized in 2004 and amended in 2015. There are two parts to it that you should understand if you do take the time to read through IDEA, which I encourage you to do. I think it's very important for all of us to understand the actual law. So birth through 2, infants and toddlers, that's, with disabilities and their families, that's early intervention services under IDEA Part C, okay? So up to that age group. And then children and youth 3 to 21 receive special education and related services under IDEA Part B. So if you have a child that is over 2, that is in that 3 to 21 range, then you should absolutely read Part B of IDEA. And then to draw the distinction between IDEA or IEPs and 504, which we'll get into as well. Legally, the Rehabilitation Act of 1973, Section 504 is what addresses 504s, not IEPs. Further, you have Americans with Disabilities Act. We've all heard of ADA, we've all referenced ADA. I want to put that out there as well. You've got IDEA and you've got IEPs within IDEA. And then you have further protection under the ADA that was signed in 1990 that extends protection against discrimination. And it's extended to public schools regardless of whether they receive any federal financial assistance. So whatever the challenges are with getting an IEP, whatever you do with an IEP, you still have this umbrella protection under the ADA to ensure that your child isn't discriminated against. Now, we'll move on to the next slide here as well, but one thing I will note is that there is a huge movement happening to reauthorizing IDEA again. It hasn't been done for a number of years. It needs to be readdressed, in my opinion, and in a lot of educational advocates' opinions, it needs to be reauthorized to address things like school choice, to address things like expansion of the disabilities that count to get an IEP and some other things. So stay tuned. There might be a reauthorization in the next couple of years of IDEA that changes it. It's desperately in need of it. But let's go ahead and go through the principles of IDEA. So we've got here 6 major principles within IDEA, the Individuals with Disabilities Education Act. Again, they are free, appropriate public education, often referred to as FAPE, appropriate evaluation, least restrictive environment, which you'll hear referenced as LRE, parent participation, procedural safeguards, and then individualized educational plan, IEP. We're going to go through each of those 6 very briefly here, and then we'll get into the meat of the presentation, which again is how to do all this, right? But I want to give this general overview.
I just want to interject quickly that I think we could have an entire session about each of these 6 principles in depth. You could have a whole course about IDEA. So this is really a quick overview. There will be confusion. There's so much more to examine. So we're just going real briefly.
In fact, when we get to the resources slide at the end, you'll see some organizations that actually do that in-depth training that goes on for 6 to 12 weeks in some cases. For parents, for attorneys, and others on this very idea, if you will, right? So let's go into the first principle of IDEA, which is FAPE, which is free, appropriate public education. And I'm not going to read the entire slide, but I'm going to hit the major points here, right? What FAPE means. It means that educational services are provided at public expense and at no cost to the parents. They meet the standards established by the state, and they are designed to meet the unique needs of each eligible student. I want you to understand that, right? Because again, free, appropriate public education, it's at the public expense. It must be established by the guidelines of the Department of Education, but it must meet the unique needs of each eligible student. So special education programs have to be designed so that your student, your special education student, makes progress toward that end, toward the general education curriculum. It has to be scaled, and a term often used as scaffold, right? Has to be scaffolded so that what they are doing and what the efforts are in the classroom and what their assessments are scaffolded so that it meets their unique needs. However, it has to make progress toward that general education curriculum. It has to be more than a minimal benefit, but with no requirement to maximize potential. Now, here's the way to think of that, right? It needs to be a functional car, but it doesn't need to be the most expensive Cadillac on the lot, if that makes sense, right? When you think of an analogy. The special education program has to be functional toward the end of making progress toward the general education curriculum, but it does not need to be the Cadillac with the bells and whistles. That's not required by law. What you are able to advocate for, and that's what we're going to work through today, right? What you are able to work on behalf of your child to get can be lots of bells and whistles, right? If you're effective at getting those things. However, there is no demand. There is no statutory requirement that the government, here the local government, provide you with the Cadillac with all the bells and whistles. Now, part of this is also extended school year services, ESY as it's known. And so Matthew right now is in ESY this month here in Florida. So he's at school 4 days a week for 6 hours a day. That is necessary to provide via FAPE as well. Let's move on to the next slide. And what we're talking about here is appropriate evaluation. Now, what I'm going to recommend here is that you take a look at your state guidelines as well. Now, this is under IDEA, under the federal law, right? An initial evaluation to determine when the student qualifies as a child with a disability. You cannot simply walk into a school and say, my child should have an IEP. That's not how it works, right? There has to be this initial evaluation where all of these steps are done, right? And you can read through what they are. A student must be evaluated in all the areas. The evaluation should include a variety of tools, et cetera. And it must be conducted. Here's a key point. It must be conducted within 60 calendar days of the parent giving permission. What we want to stress to you all today, the timelines matter, right? Schools can get really overwhelmed, really busy. I don't care, right? That's the approach I take. You have 60 days to do it. Let's find a way to do it. Now, when I say I don't care and I say it in that way, we always want to be cooperative and work with people. But there is a statutory requirement that that evaluation be conducted within 60 calendar days of the parent giving permission. I do want to note that parental permission aspect of this. I know that some of our families are guardians or foster parents. One of the things to know about statutorily is that a child that is not, you do not have full custody of, if you are a foster parent, the actual parent with parental rights still has to sign off on evaluations. And I think that's a key statutory point that you should understand as well. A foster parent cannot simply say, I think it's in their best interest to have an IEP. The actual parent with parental rights still has to sign off on that. And that's an issue in child welfare with stigma around disability. So it's just something to be aware of as well. Now, after that initial evaluation, once services are determined, reevaluations can occur several different times. They can occur as conditions warrant, as the parent requests, and the comprehensive reevaluation every 3 years. Again, statutory requirement every 3 years. That second bullet point is the most important. You have the right as the parent to request a reevaluation. You know your child. You know if something has changed. You know if there's a need to reevaluate them for their educational purposes. You can make that request at any time. Now, independent educational evaluations are also possible. This is a key point, right? School systems, as I mentioned earlier, get backed up. A lot of kids looking for evaluations at a particular time. There might be an overload in the system. You have the right to go to an independent educational evaluation and seek that, right? The easiest way to do that is to pay for it yourself. You may seek an independent evaluation at your own expense at any time, and they must consider any recommendations from the outside source. But a key point here, they don't necessarily have to follow them, right? So it's always better to work within the system unless you have to go outside. You also have the right to request an independent evaluation at public expense if you disagree with the school's evaluation. So work within the system first, but you always have the right to work outside as well on the evaluation process.
And I have just wanted to share a couple real life examples of that and what we've dealt with our own children. We did for our eldest, he had an evaluation for gifted services, and we did pay for that outside of the school system, and they did accept that evaluation because they are so backed up on doing it in the school system. However, when we requested to have some evaluations done for Matthew, because they were backed up with COVID, they wouldn't bring evaluators out into the field. They did not accept that from us. So they did get to make different decisions based on their thinking about the particular cases. In one case, they did accept the outside evaluation, and in one case, they did not.
So moving on to least restrictive environment, we're going to get into this in a bit, and we'll show you what the scale is from least restrictive to most restrictive. But what you need to know about this up front, right, is that IDEA requires that to the maximum extent appropriate, children with disabilities, including children in public or private institutions, are educated with children who are not disabled. So the goal is to have them in inclusion classrooms as much or as frequently as possible. That's the first step in the process. That's the least restrictive environment, right, is keeping them in a blended or inclusive classroom, if you will. And then you move down the line, and this is very county or school district specific as to what environments are available to them. But the idea under the law is to have them in the least restrictive environment possible. Any placement outside of that least restrictive must be justified by their individual needs. So the goal, right, is to have meaningful access to same age peers, consider providing the services in the classroom as opposed to a different way, allow them to still go to music, art, PE, trips. All of that should be accommodated within a least restrictive environment. Now, I'll tell you, right, there's always conversations about this because, well, we'll get into this in a little while, but I think that's what you need to be familiar with least restrictive environment. Now, moving on to parent and student participation. Key point here, and I'll stress this throughout the presentation, as will Carla, I'm sure. The idea is very specific about what schools must do. The law is the law is the law, right? And some schools, some counties, some states, some cities are very good. I'll put it this way. The way I've described our school system is I have said they are very good at compliance with IDEA. They're very good at being compliant with the law, right? I'm not saying that in a good way, okay? So schools have to do certain things. They have to ensure that parents have an opportunity to be active participants, but what that looks like can vary. How hard are they trying to get you to be an active participant, right? How much are they doing with you to develop and review and revise that IEP? So all of this, again, keep in mind throughout this presentation, there is the law and there is the function of the law, okay? But you have a right as a parent, and the student themselves have a right to be involved in the process per the law. Now let's move on to the next slide here, and we'll talk about.
Okay, we do have a question in the chat, which is going back to evaluation. The question is, if an outside evaluation is not accepted, should parents ask the school to provide the reason in writing? I believe that that's always your right, is to ask for it in writing. I think the question is also always, is this something I want to take that far? What's at stake here? So in my opinion, I think it would be a subjective, it would depend on the situation. What do you think about that one, Michael?
Yeah, the answer is always get it in writing. So to the writing aspect of things, yes, get it in writing. The second part of my answer is know what your appeals process is. If they do not accept it, there is a formal grievance or appeals process that you must be aware of. Go to the county website, go to the school district website, and understand what that process looks like. So when they don't accept it, your next step is, okay, what's next? I'm going to appeal that, right? If you disagree with them not accepting it, okay? And that's when, and I'll go back to the writing aspect, this is when keeping good notes is really important. So if you requested an evaluation through the school and they're so backed up, and that's the cause of you going privately to seek an evaluation, and then they deny that evaluation, you want to be able to go back and say, on this date, I requested that, and you had 60 days to do that. However, we were at 120 days as of this date. I went privately, I got this evaluation, and now you're not accepting it, right? That's when having everything in writing is really critical. I will stress that throughout this presentation as well. I will tell you that I know and I understand how hard it is to have any of that information in writing, to put things in writing. After every meeting, take a moment to send yourself an email or send an email to the person that you met. And I saw something pop up in the chat very quickly, and I'll say each school system, each district, each state, each county has different grievance processes and due process ways to handle a due process grievance or claim. And that's why I said be very familiar with your appeals process. It goes back to that first slide. Due process protects you as the parent to guide the custody and the care of your child. So a due process violation is a serious violation. You're saying that the county has violated your due process rights for you and your child. There is a grievance process that is taken very seriously for that. And I hope that addressed, state district must file, a due process. Okay, good to know, Heidi, that's helpful, yeah. Again, I will say this, right? There is the law and there's the functionality of the law. They might be required to do something to file that. But in the trenches, they might just deny that private evaluation and move on, right? And I think that's something to be aware of. So let's go ahead on to the next one here, which is procedural safeguards. You're going to get a packet anytime you're involved with anything with an IEP with 75 pages of procedural safeguards. What I think is important for you to pay attention to is the notice period. Something really, really critical, again, when I talked about those 60 days. Notice in writing, okay, and this can be waived at any time as well. A notice in writing of an IEP meeting is 10 days notice. That's for the IEP team that's calling an IEP or for you requesting an IEP. They then have to go through the process of notice in writing and give you 10 days heads up, if you will. You can waive that. I would recommend that whenever you are requesting an IEP meeting, off calendar, if you will, off of the standard functional required meetings, I would request that you say, I'm requesting an IEP meeting and I waive my 10-day notice period. I'd like to have this meeting as soon as possible. That is a way to ensure that you can get in there and start the process or address whatever you have to address quickly without them coming back and saying, okay, 10-day notice, and you saying, oh no, do it up front. I waive my 10-day notice, something that you have a right to do all the time, okay? You are entitled to access student records. They cannot keep anything from you. You have access to the IEPs. You have access to all of the educational records, any assessments that were done, any IQ testing that was done, any of that. Ask for it if you need it. Ask for it if you want it, right? And then the procedural protections we'll get into a little bit later. And this is what I was talking about with the written complaints, due process hearings, mediation, facilitator, all of those we'll get into as well. But let's move into the next slide here. And this is the IEP, right? So in general, an IEP is a written statement for each child with a disability. It's developed, reviewed, and revised at least once a year by a team. Now, we're going to break that down in just a minute, but an IEP team, be very familiar with that term, what an IEP team is, right? An IEP team is the educators, the parent, and the student. It is also the therapists. It can be other members of the administration. It can be the principal, the vice principal. It can be each of the therapists. It can be a counselor. An IEP team can be very robust, especially for our kiddos. It can have a lot of folks involved with it. But the key word here, as it says here from this source, the key word is individualized. It should never be a template. It should always be individualized.
Okay, so Michael took us through the 6 principles of the law, and one of those 6 is the IEP. So we will now get a little bit more granular about what is an IEP. So first of all, I think a lot of times people hear educational plan, but the actual abbreviation stands for individualized education program. But you might hear it referred to as a plan. That's what IEP actually stands for. And it is essentially a legal contract with the school system and the parents between the school system and what they are providing as services for the child. And this is special education services. So this is going to outline almost a blueprint of what the child is going to receive as educational services at school. This can also be called specialized instruction. Sometimes school systems are shying away from using special education as the terminology. So you might hear specialized instruction as well. Any child that is receiving special education services has an IEP. Children have the IEP from their 3rd birthday all the way through the end of their 21st year when they turn 22. So the children who are identified in the birth through 2 programs are evaluated before they turn 3, and they are put on an IEP right from age 3. That is a really great way to get started with an IEP, is to identify, and in the case of many of our children, our PMSers who are diagnosed before age 3, it is easier to do that and identify them early, have them evaluated before they turn 3. And then on their 3rd birthday, they'll go ahead and start public education services. For Matthew, that meant he started in a full-time preschool program at our zoned public school on his 3rd birthday with a one-on-one assistant right from the start, receiving his physical therapy and all of his therapies.
I just want to add statutorily, to be very clear with folks, that early intervention is federal law, right? So it may present differently through early steps programs or privatized early steps programs in each state, but it is federal law and it is federally funded early intervention. So the earlier you can access those federal programs before 3, it is critical, even if each state presents it differently in a privatized or public setting.
And that was idea part A, correct? Is the birth through 2.
Yes.
I think it just makes it a lot easier too. The earlier you can get the child in the system, started with the services, get to know the school, all of that. I know from our perspective with Matthew, everyone at his zone school knew him from age 3. He's cute, right? 3-year-olds are cute, and that helped him along the way to have built that foundation of relationships. So the earlier the better, really. I also want to emphasize that IEP is going to give your child services and rights within public schools. So if you choose to put your child in a private school, they will not use that IEP in the private school. It is for public schools. Some states have school choice programs, which we will touch on later on, but that does not have any guarantee about providing therapies, services, special education, specialized instruction in a private school. Generally
So let
speaking,
me-
that's not going to happen.
Yeah, I'm going to fly over the top with the legal side of this again, right?
This is
Which
what he does, by the way. Go on, take the legal side.
So, I think it's important to understand, right? So what Carla is saying is that you do lose rights, right? So if you do go into a private setting in the educational environment, that IEP is not applicable. That does take away certain protections. Private schools will not always tell you that. So I think it's an important point for you to understand. It doesn't mean it's a bad thing, right? But what it means is you don't have some of the federal protections. You still have ADA, and you still have a private school that you're choosing for a certain reason to protect your child, but you lose certain due process rights under the federal law if you don't have that IEP in a private setting. So I just want to make you aware, a lot of private schools have for too long gotten away without telling parents that in the admissions process. And I know a lot of states are working on that to ensure that private schools make clear to the parents, if you choose this school, you do not have that IEP. You have to start the process over if you go back to a public school. It does not carry over. Statutorily, it varies in each state as to how long that might be, 6 months, a year, whatever. That IEP goes away, you start over with a new evaluation and a request if you go back to the public school system.
Yeah, it's a really good point. And I think, we're very fortunate where we live to have some really great private school options for special needs kids. Several PMSers in the area go to these schools and are happy with them. So we do have those options, but you're more depending on the good faith of people to follow through with their school's mission and do the right thing, rather than having this entire legal backing that you have in the public school system. I default to public school. I was a public educator. I worked in many schools in New York City, public schools. So that's, the background I come from is public. Okay, so just some clarification about what an IEP is not. I hear people saying, oh, we have an IEP today. It's not the meeting only. That is an IEP meeting. So I think language matters, because it isn't just a meeting. It is this entire program that is created specifically for your child's education. The meeting is a small part of the process, a very important part of the process, but it's not the whole thing. The IEP is not instructions for Mrs. D'Imperio to follow with Matthew. It's not for one teacher or one staff member. It is, in Matthew's case, it's a 25-page guideline of his education that can be handed off to different teachers. So for example, he's at extended school year for the summer. They get his IEP, they know what they do with him. They know how much speech he gets. They know what his health needs are. All of that is outlined here. So it goes with him from teacher to teacher and classroom to classroom, even school to school. It's not a lesson plan. It's not a curriculum. Teachers still have to make their lesson plans and teach the child. They have to use the curriculum provided by the school. So it is not breaking it down into anything like that. It is not support for disabilities that don't affect education. In the case of our children, of our Phelan-McDermid kiddos, their disabilities do affect their education. I think it would be very surprising if there was a child in our population that didn't qualify for an IEP. However, there are children with disabilities that don't affect their education. An example could be someone who needs glasses, or someone with food allergies, someone who has a limb difference. So in that case, that's where Section 504 comes into play, and it's a different type of plan that provides accommodations for the child. We'll get into a little bit later what accommodations are versus modifications, but that is a different law. For IEP, it has to be a disability that affects their education. And as Michael talked about earlier, it affects the education through this whole assessment process, the appropriate evaluation.
So I think there was a really good point by Heidi put into the chat as well, Carla, that we should talk about. And again, this is where you can get really into the weeds, right? And this is a great point, though. When you do access private education, you can keep your IEP, as Heidi mentions, right? You can keep an IEP and you can give it to the private school. You can still access certain public services through that IEP. However, and the key point again, and what I was trying to make, you don't have the statutory federal protection of that IEP. The private school does not have, they do not have to legally follow that IEP. You do not have the same due process and grievance vehicles available to you if they don't. But you can certainly, I think that's a really good point, you can certainly keep that IEP and access IEP services. And it's one of the reasons, maybe me, I don't know if Carla is as strong about this as I am. I am a huge advocate of school choice and the way that Florida does it, because one of the things that you can do is you can access a variety of resources under the public education system. And we'll get into that later, but you can essentially, Heidi, what you're saying is you can take the best parts of the IEP that you create, and you can do a little bit of homeschool, a little bit of private school, a little bit of therapy, a little bit of hippotherapy, a little bit of art therapy, all of these things using the public funding that your child would have gotten from public education. So ideally, what you're talking about is the ideal, and one way that manifests, if you will, is in Florida under the school choice program, which is ridiculously good. So yes, I think it's a really important point. You can still access that IEP, but again, statutorily, the private school doesn't need to follow it by law.
Okay. No, that's a really good point. And I think that's there, it does vary state to state, and there is a lot of opportunity as you get to know what your state offers to learn more and be more of more empowered, because then you can start to do that, piecing things together, really thinking critically about the program for your child. You know, we're hoping maybe we can do a 102 session and get a little more into some of this, like school choice, some of these more specific things, because it is really interesting. There's a lot of opportunity. The last point here is special education is not a place. It's not like you go somewhere and it's special education. It is the services outlined in the IEP, the program that the child receives. It can happen in a general education classroom. You can have push-in services where the person, the therapist, the special education teacher goes to the gen ed classroom and services the child there, so that it's not a place that the kid goes to a special education. Okay, so to be eligible for an IEP, there's two requirements. There's the child has to have one or more of the 14 specific disabilities listed in IDEA, and the disability must affect the educational performance of the child. So as assessed in those evaluations we talked about, so that they have to have the disability, and the disability must affect educational performance. Okay, so also here, the first thing that would be determined is the educational program, the IEP itself. Then they might say the child is going to be placed in a different school or a different classroom. We'll get into that a little bit more in a minute, but it's something to keep in mind. So the 14 disabilities listed in IDEA, I'm not going to read through all of them, but these are the 14 listed in the law, and I've highlighted the 4 that Matthew has in his IEP as his exceptionalities. So you can use as many as your child qualifies for, should all go in the IEP. They should go. His primary we have is other health impairment. We did not at this time want to put him in an autism unit, is what it's called. So his autism diagnosis is a secondary one. It's under other exceptionalities. Speech, he has the language impairment, and then intellectual disability. The ID, intellectual disability, that was a big process of requesting the evaluations, consenting, having a lot of evaluations done to get him that ID designation in his IEP. So I would say that our PMSers, most of them probably have more than one of these eligibilities, which then would make them eligible for an IEP. The process, so it is always a process, right? That is the key word here. This pre-referral is the first step in the process, and that's not really this concrete step. It is this the period before a referral, before the evaluation happens, when the teachers, the parents, everybody is observing and gathering information about a child. So if we look at the birth to age 3 range, that would be when your child's home or in daycare and you're realizing, okay, they're not meeting their milestones, they're not speaking, and you start having, maybe the pediatrician refers you to physical therapy or speech eval and all of that. That is data being gathered by the family. And then at some point you get referred to the early childhood services that Michael was talking about, the IDEA Part A. And they would evaluate the child, and at that point, the child would qualify for early intervention. That's how it went for Matthew. So that happened during that birth to age 3. I guess the law calls it birth to 2, so that he had all the evaluations and referrals before he turned 3. The other way that it could happen would be maybe the child has been delayed and the family has been looking for answers. Maybe you don't get your PMS diagnosis till your child is 7. Your child's already in public school. At that point, there's been data gathered, the child isn't progressing, whatever the case may be. And at some point, all of that pre-referral information would then make the school system or the family request that evaluation, request the referral. So that's the second step, is this request where you have a referral, the child then gets the evaluation and is identified as whether or not they qualify for an IEP. I think that we've already said this, but the earlier the better. If the child is identified before age 3, it opens more doors in terms of what's available earlier. But after age 3, they still are entitled to all of the same protections under IDEA and IEP. So that would determine, then they would have their evaluation, step 3, identify whether or not they would qualify for an IEP. And then step 4 is, what are those eligibilities that we just talked about? So is it an other health impairment as the primary exceptionality? Is it language impairment? What is the eligibility that is then dictating the development of the IEP itself? And again, it can be many eligibilities, but you do have to choose a primary exceptionality. That will then dictate the IEP development, which is the next step in the process. So you've gone through the evaluations, which can be lengthy. Maybe they want to do an evaluation for ASD, which can require observations and filling out all kinds of inventories. Intellectual disability, that's a whole IQ test that maybe it didn't work the first time and the child wouldn't cooperate, so they have to do it again. So this can take a lot of time. And then at that point, that's when you sit down with the IEP team and do this IEP development, where the team will have a drafted IEP and the parent sits and gets to give input into the changes they want, what they agree with or not. At that time, the parent has to sign off on accepting that, yes, this is the IEP this is the program for our child that we agree to, or not. The family might want to wait and have another meeting. You don't have to sign it that day. So Michael will get more into that, but that's that step. You develop the IEP, say everyone agrees and it's wonderful, then the implementation happens. So the IEP would have a start date, which is called the initiation date. That's when all of the services, all of the whole program would be implemented. And then there would be a date where it would have to be reviewed and reevaluated. So a review happens annually, and the re-eval is every 3 years unless requested or needed sooner. Now, some cases, the re-eval would say they don't need an IEP anymore. The child has met all the goals. They don't qualify for an IEP anymore. In the case of our children who do have a lifelong disability, that's generally not going to be the case. Okay, let's move on here. Okay, so this is a lot of things here for the parts of an IEP. Unlike the 6 principles of IDEA, which there are 6, that's it. There could be 50 parts of an IEP. We could list them all out here. It really does vary state to state, but these are the parts that are required to be there under IDEA that I kind of prioritized as the most important parts. There are a few others we could have added, but this is a good starting place. So The IEP itself must have present levels of academic and functional performance. This is basically a description of where the child is right now in terms of academic and functional performance. So it might include some data. There might be observation notes. There could be some narratives explaining like the child's favorite activities, the child's behavior. This is really to give whoever's reading it some detail about the child. So imagine you're a new teacher, you're getting Matthew in your class this year, and you read through these paragraphs describing his performance, his interest, maybe what triggers him to get upset, things like that. It can have test results in there and grades, and there's other abbreviations. You might hear it called the PLAF or the PLOP or the PLEP. There's so many acronyms. So present levels is the way that I refer to that. That's in the case of Matthew's IEP, it's several pages of writing description about him. Then there's going to be academic and functional goals. So the IEP has to have goals. They have to be measurable goals, and they should be challenging goals, but also reasonable that the child can actually achieve them. The goals are tied to various domains. So in the case of Florida, our domains are curriculum and learning environment, independent functioning, communication, social emotional behavior, and healthcare. So if you have one of those domains checked in the IEP, then there must be goals related to that domain. And you can see they're not all related to curriculum and learning. There's also like the healthcare goals and communication. So there's a variety of different goals there. Generally in the IEP meeting, Michael and I really like to let the teachers and the people that are with Matthew be the ones that really develop those goals and kind of let them take the lead on that, because that's an area where the educators can really feel empowered. So that's generally not where we're going to be as vocal. Okay. There's also going to be a statement of special education and related services. So that's where it will outline the child's time with the special educator, however that looks. So in the case of our child, he currently is with a special educator all the time. So it has to actually say the number of minutes per week that he's with her. And then related services are things like physical therapy, occupational therapy, and speech therapy. There might be behavioral therapy. The other therapies would be considered related services. And again, that it has to say the number of minutes of the service. If they try to say the service is going to be daily or as needed, you want to get really specific with the number of minutes there.
Yeah, I think this is a key learning for me, who didn't come from the educational background, right? So Carla mentioned that we like to allow the people with him to decide on the goals and dictate the goals. However, I will tell you, key learning for me, the number of minutes is a material matter. It absolutely is. You need to know what a number of minutes or a range of minutes means for environment, because if a certain number of minutes are dedicated to pull out services, go back to that least restrictive environment conversation, right? If your child is in the least restrictive environment, and that is an integrated classroom, and you ask for a certain number of minutes for pull out PT or pull out speech therapy or pull out OT. And as humans, our instinct for our children is get them as much as we can, right? So I want the most number of minutes of PT because he really needs it. At some point, statutorily in your school district or your state, that will trigger a different environment if they are pulled out for too many minutes. Okay, so a key learning for me was working with our IEP team to understand, okay, how many minutes can I have for each service for Matthew before it triggers a different environment? So just something to be really aware of, acutely aware of, is that instinct of wanting the most minutes, but understanding that if we can integrate those minutes into the classroom, as opposed to pull out services, difference between push in and pull out, they won't trigger a different environment, right? So just pay attention to those minutes and know what the policy is. Ask your IEP team, right? What does it mean for the number of minutes? Can we ask for more without triggering whatever it may be? So just a key learning there.
And I'm looking at in his IEP, there's things, so he has intensive instruction in self-care is one of his specially designed instructions for 170 minutes per week, focusing on washing hands, toileting, and feeding. And that's related to that healthcare domain where he has a goal. So it all ties together. If you have a goal in a particular domain, then there should be specially designed instruction, which is the statement of special education, that fourth bullet point. There should be minutes or services outlined in that section of the IEP that match. It should all be aligned. That's important. Okay, so, and then under the related services, that's where the OT, PT, speech, all of that would go. And the other thing that goes there is transportation. So if your child is going to ride the bus, do they need a wheelchair bus? Do they need an assistant on the bus? That's going to go under related services.
A key learning there, I'll add too, sorry, Carla, is because she came into this with so much knowledge that I had to learn. If you anticipate that they might need the bus, right? And you're not starting the school year there, right? At this IEP meeting, you're saying, I'm going to drive my child. They're not taking the bus, but they might need it. It is a heck of a lot easier to get that into the related services up front, then come back and get it later and open another IEP meeting and go through that entire process. So my recommendation is for things like that you might use, go ahead and put them in related services and then turn them down in that moment. Understand what that means, that if you don't use the service, understand what the law is in your county and your state as to what can be put in there and you must do, as opposed to we're requesting transportation services and then we're not using them right now.
And another thing with the transportation is you can request the stop be close to home. And there, there's medical arguments with our children about he has to be dropped off in front of the house because he overheats, et cetera. There's ways to justify that medically if there's any pushback. We still have transportations in the IEP, even though he's not using it right now. So to Michael's point, it is good to have things like that. Then that we have the next section is statement of supplementary aids and services. This can vary. This is all kinds of things can go in there. So for Matthew, the school system purchased his communication device. So that's where his communication device goes, is in the supplementary aids and services. And then there is a number of minutes per week related to how someone's assisting him specifically with that. That does align to a communication goal from that communications domain mentioned earlier. So again, it all aligns through the IEP. He also has one-on-one assistance built into the supplementary aids and services. So if your child needs a one-on-one assistant, that's the place where you're going to have that outlined, getting very specific about the number of minutes per week they need the one-to-one and the parts of the day where they need it. That's a big one because a lot of our kiddos do need the one-to-one assistance. Okay, so moving on here, we have the accommodations and modifications we'll get into more later, but that is something that's in the IEP. There's a lot of dates. So the projected date for starting the services, the frequency, location, and duration of all services, which is what we've just talked about with the minutes. Transition planning for older students. This is something that we could have a whole session about, but generally the state law is going to, state guidelines are going to say between 14 and 16 years of age, there should be transition planning in the IEP for when the child graduates or finishes high school. What are they going to be doing through that age 22 period, and planning for adulthood really. Testing adaptations, and also as anything in IEP, parent input must always be taken into account. So parents have a chance to fill out some paperwork beforehand with their thoughts as well. Okay. So just to talk about modifications versus accommodations, an accommodation changes how the student learns or accesses the material. It does not change the material accessed. So it could be a child who has a processing disorder who they'll read the same book, but they will have the audio version, so they don't have to actually read the book. It could be a child with a visual impairment who needs a change of seating to sit closer to the front of the room. It is not a change to what they're learning, it's a change of how they're learning. They're accessing the same curriculum. Generally, these things, if they're in isolation and not in addition to modifications, then it would live under a 504. A modification is changing what is taught or assessed. So the actual curriculum itself, are the standards being scaffolded down, as Michael mentioned earlier. For Matthew, he's on alternate standards, which are a more basic version of the state standards. He doesn't have to take the state test. So that's a modification. Other children do, he doesn't. It's changing what's assessed for him. And that is going to live in the IEP, all of these modifications, because it's a change to the actual program of the child. Trying to go a little quicker here. Okay, so least restrictive environment, there's a whole section in the IEP that's going to check the least restrictive environment, make sure the child is in the least restrictive environment possible, because IDEA protects that least restrictive environment. This gives an example of some of the environments and how they get more restrictive, but these are only some examples. There are many, many examples of how you can restrict a child's environment. So the least restrictive environment is general education classroom. It's your mainstream kiddo who doesn't have an IEP, doesn't have nothing, no accommodations, no modifications, would be in a gen ed classroom. Our son, Joseph, is in a gifted program at a gifted school. That is already a more restrictive environment because we are taking him away from his gen ed peers. So it's not just with disabilities, it works with that type of situation as well, where it's taking the child away from the gen ed peers and placing them in a more restrictive environment. So moving up from the general education classroom, if the services are provided as a push-in service where the therapist or special educator comes into the classroom to work with the child, that's a little bit more restrictive. The next step would be to actually pull the child out of the environment for those 30 minutes a week, 60 minutes a week to receive their speech therapy or whatever the case may be. You're restricting the child because you're taking them away from their general education peers. The next step up is where you're taking the child away from the gen ed peers for most of the school day, which would be a self-contained special education classroom. In this case, as mentioned before, the child might still eat lunch with gen ed peers or have PE with gen ed peers. The school system is going to want to provide times where the child has access to general education peers. If there are no minutes per week with gen ed peers, then you're talking about putting the child in a center school environment where it's a special education school and the child's entire day is with disabled peers. And again, that might be a perfect environment for your child, but it's going to have to be justified. There's going to have to be evaluations, and there's going to have to be a case made for why that's the least restrictive environment for that specific child. And then the most restrictive is going to be hospital homebound. So that's when the child actually cannot go to school and the teacher has to go to the hospital or into the home due to medical reasons. Now, if you take a one-on-one assistant and add them in here, they're just going to take whatever point it is on this spectrum and make it a little bit more restrictive because now they have that restriction of having the one-to-one with them. So there's also a lot of justification that's going to go into being able to get a one-to-one assistant for the child. Should I go into hospital homebound at all?
I don't think so. I think that's an extreme, right?
Yeah.
So on a temporary basis, I think, well, I'll say this, it was used a lot. Let me say this, it was used more frequently during COVID. I think some special education parents realized that was a really good way, as did we, right? That it was a really good way to get the services Matthew needed without being in a virtual environment that wasn't functional for him. But it should be looked at as a temporary environment more than a permanent solution. I'll say some key learnings about the least restrictive environment that Carla covered, but I want to highlight. There's blending within here as well, right? These aren't distinct points necessarily. And I think that that's where a relationship with your IEP team and conversation with your IEP team really comes in handy. I remember specifically when we were talking about putting Matthew into a self-contained special education classroom, one of the key learnings for me was the vice principal at his current general education school and classroom saying, okay, let's build in minutes where he goes to PE or he goes to art with general education children so that that's balanced and it's not, the IEP doesn't reflect that he needs to go to a center school, right? So there's ways to have those conversations. Always think about that balance of minutes that I talked about earlier. There is a point where you trigger something. You have to know what that point is in communication with your IEP team. Know what that point is so that you can balance those minutes and do what you need to do to get the environment that you're striving for. I always think of this as the dog and the tail, right? The dog wagging the tail, tail wagging the dog. What do you want and how do I get there? Not let's go into the IEP meeting, start putting everything in and see where it leads us. That's not as effective. Where do you want to be? What are you striving for? And how do we get there? I think is a more effective way to manage the IEP process.
Yeah, and I think that there's a different perspective here too, where you flip it and think, this wouldn't be the driving force, but I think there is value to having disabled children with their gen ed peers for the general education children to be accepting, kind, patient, loving, and so we think about that a little bit. It's a little bit of part of how we think about things for Matthew is that he can add a value as well. And the other thing I wanted to say is that there is room always to pull away the restrictions. So if at the re-eval, they say, okay, he doesn't need to be in a center school anymore because he's met these IEP goals and he's made progress, we're going to put him back in a less restrictive environment. That can always change. It's fluid. It can move both ways. Okay, I think that's probably good on that front, Michael. So I'm going to hand it back to you for conflicts and disputes.
Oh, why would I be covering conflicts and disputes?
Have fun.
So there's been, I'll say this, right? There's been a lot of discussions Carla and I have had about how to handle the IEP process, what the relationship looks like with the county, with the school. I'm in law school for a very specific reason at my age, which is, I was tired of the BS. I wanted to advocate more fully for kiddos like Matthew. And you can see the genesis of that, right? Is that I don't really handle the conflict and dispute well. I don't, I'm going to get what I'm going to get. I'm going to be a bulldog and I'm going to take care of my child. I have learned a lot about the process through the years, at Carla's expert guiding as well about building relationships and community and that kind of thing, which I think is incredibly important. I have taken the role of the bulldog though, and she does a really nice job of building the relationships in the community, and that works well for us. That's not going to work in all cases. I would encourage you to think about, if you do, have a parental partner in the situation, what your roles are. I think there can be dual purposes and dual roles. And I have embraced the conflict and dispute bulldog role. And I am well known within the county as that bulldog. And I'm okay with that, right? So here's the thing though, right? There's going to be conflict. There's going to be a difference of opinion between you and the school in certain circumstances. There's going to be disputes. That does not mean that you have to give in. I go back to that first slide and why we started there. You have parental rights. You have certain constitutional and due process rights, right, that you should be aware of, and you should hold on to those. However, you have to recognize, as Carla has reminded me many, many times, we've got an ongoing relationship with this county and with this school. How far am I going to push things? How am I going to present myself? So a couple recommendations that we'll walk through. And Carla, if you want to add anything there first before I walk through
I wanted to just say that was kind of Michael and I are always coming at things differently. I'm definitely softer about a lot of it because these are the people we're going to be working with until Matthew's 22. It's the same people, right? The same system. So let's work together. And that's why sometimes, in my opinion, you don't want to demand everything in writing because that's where I was saying earlier, like it can be subjective at times. And there's a lot of, now Michael's in law school, he's going to say everything in writing, everything in writing. I think that there's always this in every aspect of this, pause, think about what am I trying to get here? What is we like to use the phrase hill to die on. Is this a hill to die on? How important is this? Is it contributing to the Cadillac, like the fancy car, or is it the car that they're going to give us, and that's not saying lower your expectation, but recognizing that this is a system. Generally, people do want to help kids and we want to work together and try to have a relationship. Now you can go on and be harsh.
She's right. She is right. So here's what I'll say. I think whenever a conflict arises, I would recommend that you identify the root cause of that conflict, right? So I am not a fan of bureaucracy. I think things can really get bogged down. I think that often people are doing their best working within a system. And I think that's important to remember. So when you look at it that way, you can start to identify the root cause of the conflict. Is it a misunderstanding? Is it a data issue? Is it some sort of lack of resources, or is there a law being broken? A law being broken should always be the extreme, right? It should always be, I don't think, again, it goes back to that least favorite word I've got, demand. We don't demand anything, right? We have certain rights under the law. We understand what those are, and we're going to work within the process to get our child what that child needs. However, if the law is being broken, it's a whole different ballgame. It's a whole different conversation. And I'll take you through a story in a minute that we had to deal with on that front. But if you can take a look and take a step back and take a breath and identify the root cause of the conflict, then you have a better chance of solving it because you can work within the process. Is it a data issue? What did we miss? Was there an evaluation not done? Was the IQ testing not done right? Can we have a conversation about that? Is it a misunderstanding about what I said I want for my child and what you think? Let's address it that way. And then you have to consider the source, okay? This is no different than any sort of conflict resolution or dispute resolution that you've ever thought through, but consider the source. Who is the person that is recommending or prohibiting something from happening? Is it a member of the IEP team? Is it a therapist? Is it the principal? Is it the county? Is it somebody at that level? Who is doing it and why, right? And then the issue can be looked at differently. Now I know the root cause and I know who. Now I can say, all right, do I have to address this through an IEP meeting, or can I address it differently? If I have to address it outside, let me rephrase that. If I can address it outside of the IEP, that should always be our preference here. You're going to get more done outside of a formal IEP environment. Can I take a cooperative approach and suggest the issue be handled informally, right? Can I say, okay, this seems to be a data issue, or this seems to be a misunderstanding with the physical therapist or with the special education teacher. Let's have a conversation and figure out how to address it in the immediate, solve the problem, and then we will formalize it in the IEP process when it comes up, or down the line, or I can request that meeting and start that process. But my most immediate need is solving the problem for my child. And can I do that outside of the IEP environment? If not, request that IEP meeting in writing as soon as possible. Consider waiving your notice period, as I recommend, and I will continue to recommend. Consider waiving that notice period and get the issue handled formally if you have to. That's going to be the case when it is coming from a higher level, right? It is coming from somebody in the county, is requiring more testing. Okay, not something I can probably handle outside of the IEP environment. We need to go formal. We need to get that done as quickly as possible. We'll handle it that way. That leads to the idea of escalation, right? And escalation should be a last resort. However, go back to that first slide, you have rights. IDEA is law. It is federal law. You have rights. Escalate if necessary. If inaction is causing a bottleneck, do not wait and hope it resolves itself. Escalate. I will go back to what I said that Carla just pointed out, in writing. Put it in writing. Escalate in writing. Phone calls, emotional phone calls, not always effective. Okay. Outline your case. Yes, I think like a lawyer, but I will tell you that one of the most effective emails I have ever sent was when the county, absolutely, in my opinion, broke the law with Matthew's IEP. I had a very clear timeline of what happened, and I had a very clear ask and consequences that could occur in that email. I will tell you that I got a meeting with the head of ESE within an hour, right? Because that in writing with reference to dates and people was very, very clearly outlined. And they knew, for lack of a better term, I won't say that, they screwed up, right? And they knew that because of my timeline and everything I had, they had to take action. There was a bottleneck. They were saying, we need to do X, Y, and Z. We need more time. And Carla and I looked at each other and said, there is no more time. We have taken too much time. He's in the wrong environment. We need to change this. That's when we escalated. We had tried to follow the process. Remember, School systems are a bureaucratic environment. They are a government function. This is not a political statement. It is a reality. Within a system, there are going to be bottlenecks. There are policies, there are procedures, and there are people who work for that environment. There are people who have worked for that environment for 20, 25, 30 years, right? And you coming in and escalating things, the fallback is usually process and procedure, okay? So if the more you can circumvent those policies and procedures by having clear in writing dates, times, people, and requests, the better off you're going to be. And then I'll end this slide with the point that we were just talking about. There's a time and a place for lawyers and lawsuits. As a future lawyer, I will admit that very openly. It is not always the right environment for consultants, for advocates, for lawyers. Doing that escalates things in a way that the school system will put up their guard. Our county is very good at compliance. That's what I keep saying. They are going to be very good about checking those boxes. Gives me very little legal wiggle room for lawsuits because they're complying. And when they screw up, I'm going to call them on it, but they're complying, right? It goes back to, we've got to provide a car, but not the Cadillac with all the bells and whistles, right? If they're complying, they're complying. Okay, and that's something to be aware of. So I think, again, in conflict and dispute resolution, just think about how can I handle this informally? How can I handle this in a cooperative way? Can I identify the root cause? Can I consider the source? And can I handle it outside of the IEP process? If not, we default to the IEP process. If not, we default to escalating. And as an extreme, we look to educational advocates or lawyers to handle a legal issue for us. But it also, and we'll get to this in a slide or two, I think we're almost done, but know your grievance procedures as well. We're going to talk about that, right? Know your county specific grievance procedures. If this does not work, if I run into a problem, I don't have to jump to lawsuit. I can go to mediation. I can go to facilitated IEP. I can follow the due process claim as Heidi mentioned earlier, right? I can do all of these things. There's all of these procedures and protections because, again, it's federal law, right? And they do not want to be tripped up on federal law. So let's move on to this next slide. And I've been kind of real here as we've gone through, but it's time for some real talk too, because I think that understanding the realities of the situation are really important. I have mentioned several times, the law is the law, right? The law is the law. However, the function of the law varies by state, district, county, school, etc. Okay. So we have to understand what each person's interests are, what each party's interests are in an IEP setting under IDEA. You've got the IEP team and you've got parents, okay? Let's be real talk. If I'm going into an IEP meeting, I should keep in the back of my mind one simple rule. The school and the county has to look out for the school and the county. There are limited resources and there are limited budgets, okay? So if I go into a meeting, especially my first IEP meeting, or when I'm making a big ask, I'm always keeping in the back of my mind, they might try to limit my ask. They might try to push back on minutes. They might try to limit services. Why? Not because they don't care about the child, but there might be one physical therapist in the entire school district. And now you're asking for X number of minutes that's going to demand a lot of that physical therapist's time. And while that might be the right thing, if you've ever managed a budget for a company, right, might be the right thing, but there's only so many dollars, right? And if this goes through, if I'm required to provide this physical therapy and these minutes, as a school, as a county, I've got to hire a new physical therapist. And I might be in the middle of Iowa, just picking a state, right? I might be in the middle of Iowa where there's limited number of physical therapists in my area, right? There's not a physical therapy school close by. There might be a limited number of physical therapists. Nebraska, it could be New York, it could be anywhere, right? There could be a demand on physical therapists. I can't get. So you have to understand each party's interests. One of the things that we are pushing back on in Florida, and in our county specifically, I'm pushing back on, and you should be aware of, is that our IEP meetings are facilitated by a compliance director for the county. Yeah, that's not okay with me, right? Because the compliance director has the state interest, the county interest in mind when she's facilitating that meeting. While she's only facilitating, let's get real, right? She is guiding certain conversations certain ways. So what I'm advocating for in our area of Florida is a third party neutral to facilitate any IEP meeting so that there's no conflict of interest. So first thing, know what your party's interests are. Be aware of them. My sister's a first grade teacher, has a big heart. She is the aunt of Matthew and cares deeply about kids with special needs. However, she will tell me, honestly, I walk into an IEP meeting and my principal has directed me, on budget issues and other issues, right? And that's in New Jersey, where the cost per pupil is much higher than Florida. She's been directed or given knowledge about certain things going into IEP meetings, okay? That leads to the conversation of what kind of budget is available, right? Per pupil cost breakdown, know what it is in your state, right? Nationally, I believe the average right now, average per pupil is somewhere around $10,000 or $11,000 per pupil nationally. In states like New York, I believe the number is upwards of $23,000 right now. Whereas I think in North Dakota, it might be $7,000. In Florida, it's 10, and the national average is 11. Know what the per pupil budget is. It's just a nice number to know as you go into these conversations. And then think about, again, getting real individual first shared services. Goes back to that issue I talked about with physical therapists and other therapists and services. They might recommend shared services simply because they don't have enough therapists to go around, right? Understand whether that's in the best interest of your child or that's a convenience for them. Again, they have to provide something. They don't have to provide the catalog. So be aware of that. And then
can I
services.
just give an example about that, about the budget breakdown? So for Matthew this summer for ESY, he's there for 16 days. It's his extended school year. It's outlined in his IEP, but it's 16 days. In his IEP, it is outlined that he needs assistance, one-on-one assistance during extended school year. They don't have any assistants. They have 3 open positions at the school he's at. There are no people willing to work that job for the summer. So he's in a classroom where there's 5 children and 3 adults in the classroom. It's not going to happen this summer for him to have an assistant. Unfortunately, that's the reality, right? And it's kind of those budget things when they do sometimes make the decisions. It's not ideal. But in this case, that's the way that it went, and it's only 16 days. So we're kind of like, okay, we're okay with that right now. I don't know if that's helpful.
It is. It leads to the conversation of what's law versus what is functional and possible, right? Same thing, resources available and enforcement of the law. So again, buses have been a problem in a lot of counties around the country. In a lot of your states, I'm sure busing has been a problem over the last 1 to 2 years. So you may have a need for transportation, wheelchair transportation on a bus. If that bus is not available, again, the law and functionality of the law, right? For ESY, Matthew's classroom was fairly empty the first week. Why? They didn't have handicap accessible buses for the kids to get to school for ESY when it's only a 4-week program, right? 16 days. They didn't have it the first week. You can shout and scream and cite the law all you want, but in the case of the one-on-one aid or the bus, it simply wasn't available. They didn't have it, right? So it goes back to that again, what is the law and what is the functionality of the law? I'm going to jump up back to unique services for just 1 second. And that's a function of school district budgets and what they look like as well. What kind of services are available? Do they have art therapy in a school district? Do they have music therapy? Do they have hippotherapy? Do they have any sorts of things that you can work into your IEP? Or are you in a school district where those services aren't available or they're more limited? I make a comment about states around the country that might have things and might not have things. It's a function of people, right? It's a function of, are there therapy schools? Are there universities close by? Are there people being trained in those things? That's just a reality of the situation. Whereas a school district in New York might have much more access to therapies, unique services, and another state, another city, a more rural community, for instance, might not. And it's just something to be aware of as you do your IEP. Carla mentioned earlier our favorite phrase, and it's not pleasant, right? But it's something we think about all the time. What's your hill to die on? Is the issue that you're addressing? Is it your hill to die on? Am I going to the mat? Am I taking this am I escalating as far as possible? And am I absolutely is this a must have? Is this necessary? Or is it a nice to have? It's something that I think we learned a lot through the IEP process. We went in very early, we were going to get everything. And then it became, is it necessary to get everything, or are we asking for too much? What do we need to ask for Matthew to thrive in his educational environment? What's necessary versus a nice to have?
Yeah, and that's where that assistant for the summer, it's not necessary. He's fine. He's in a classroom with 3 adults. He's good. But if it were the school year, if the stakes were a little higher, it would be different. And I think the other piece here is whoever you're sitting with at that meeting on the other side has a hill to die on too. So you've got to give a little and let them have some wins, and think about, what do I need to have as a win? What's the most important thing for my child? And I think that's how the relationship goes.
Yeah. So we're running short on time. So I'll cover that very quickly. What are the limits to the system? Know them. Know when to hold them, know when to fold them. Be aware of school choice, know what your state law is on that, so that you do have other options or opportunities. Let's go to the next slide. Talk about some recommendations really quickly. I know, again, it's dry and boring and not fun at all, but know the law. Read each part of IDEA you should read. Know the ADA law, know local policies, know precedent. We were told very early on with Matthew that there has never been a preschooler assigned a one-on-one. Well, we got one, right? That was nice that they had never done it, but we were going to get one for Matthew because it was necessary for him.
There's no way that the county will buy his speech device, they told us. That's never happened. They did. So
you can tell we are big fans of setting precedent too, within a school district that other kids can then rely upon. But know what the precedent is. Be aware. Build your team. Again, goes back to Carla's much more gracious approach to things. Build your team. Teachers, therapists, school administration. I will tell you that in all of our IEP meetings, the IEP team, the school-based team, had our backs because we had theirs. We start every relationship in a new environment with a new teacher by explaining to them, what you need, we will get. We don't care about the county. We don't care about, let me rephrase that. The principal is less important to us than you are, the teacher. What you need.
This is being recorded, Michael,
What you need, we will get. And we mean that genuinely. We build that relationship with the teacher early on to explain, like, we will go to bat for you to support our child. Please tell us what you need. That has led to some really strong relationships. And when we've needed it, when we've had to go to the mat, when I had to take the issue to the county, I had information given to me by the local team, for instance, right, that maybe I shouldn't have known. Okay. That's important because I had knowledge then that helped me with my discussions, right? So build your team very carefully. Non-school employees as well. That can be, you always have a right in an IEP meeting to bring other resources with you. That could be other therapists your child is seeing. That could be doctors. It can be doctor notes. It can be advocates and lawyers as well, if you need to. Just know and be aware, again, as a future attorney, that escalates things. You walk in with an educational advocate or a lawyer, backs go up a little bit, right? And compliance is a much higher priority for the school and the district at that point.
And from the other side, if the school district is going to have a lawyer there, they should notice you that, and you should have the opportunity to bring your own counsel.
Yep. Create a plan, like we talked about before. Use the IEP process to get to your end goal, as opposed to doing the IEP and seeing it where it leads you. Know what you think is best for your child and advocate for that. And then know available procedures and grievance policies. It will be on your county website, your school district website. Know what that looks like. You can request, in some cases, statutorily, a facilitated IEP meeting. You can request a mediator. You do have due process grievance rights, dispute resolution, and then the grievance at the state level as well is very important to understand. Let's go to the next slide, the last slide. Where do I get good information? A couple resources here. So you'll see our emails on the left. Please, get in touch with us. We will do what we can to help you. Carla mentioned we'll probably do a second IEP session at some point if people want one where we go a little deeper. Start macro, start with the federal and local government laws. Go to the Department of Education website, read IDEA, State Department of Education, look at their policies. I'm giving you an example of the ones here in Florida. And then your state health department has some really good information as well. County and district school websites is going to give you the policies. They're going to give you the grievance and dispute resolution, contacts, parent guides, all of that. Council of Parent Attorneys and Advocates, CPAA.org, COPAA.org. I'm a member, really good information there, discussion boards where you can put things out. It's parent advocates, really great training that books really fast. They offer it every couple months for special education, so check that out. And then Center for Parent Information and Resources as well is down there at the bottom. So let's see if anybody has any questions. I know that's really a lot of information. And we talked a lot, but I'm hopeful it was helpful.
And these slides will be shared after the session as well. If you wanted the resources in the previous slide, they will be shared.
I will say this again, there's a lot here. As a parent, you have the right to advocate for your child. All the information that we shared is learnable, right? It is very learnable. Take the time to learn it, walk into a meeting prepared. Or else that you can absolutely be guided in certain directions without knowing any better. And I just would advocate for you to know the law and know what your policies are. Okay. Carla, anything else?
No, I think I'm hoping we can do some more. Maybe I'm thinking maybe a workshop where people can bring their child's IEPs and we can work on them. So hopefully more to come. But thank you all and hope you have a great day.
Thanks all.